The applications for judicial review by Francis McGuigan and Mary McKenna concern the very serious ill treatment of people who were detained by the security forces for interrogation by the Royal Ulster Constabulary in August 1971. Francis McGuigan was one of the 14 men who became known as the Hooded Men, who were subjected to this wholly unacceptable treatment, which we describe in paragraph 74 of our judgment. Another was the late Sean McKenna, the father of Mary McKenna. Concerns about this ill treatment led to the United Kingdom government appointing 2 committees of inquiry in 1971. The important legal questions raised in these appeals include questions as to the circumstances in which public authorities in the United Kingdom would be under a duty under the Human Rights Act 1998 to initiate an inquiry or investigation into a death or ill treatment under Articles 2 or 3 of the European Convention on Human Rights, which I'll call the Convention, where the relevant event occurred many years before the Human Rights Act came into force on the 2nd of October 2000. Another important question is how the domestic courts are to assess the ability of the Police Service of Northern Ireland, which I will refer to as the PSNI, to carry out an independent and effective inquiry or investigation into such events which occurred during the Troubles. No one has ever been identified as responsible and prosecuted for the killing of Ms Smyth. At the time of her death, the Royal Ulster Constabulary considered that her death may have been the result of the actions of an unidentified member of a paramilitary organisation. But in June 2014, military logs were disclosed which gave rise to the possibility that the shot that killed her might have been fired by a member of the military reaction force of the British Army, which was operating in that part of Belfast at the relevant time. In response to this new information, the Chief Constable of the PSNI proposed that a further inquiry into Ms Smyth's death be carried out by the Legacy Investigation Branch, the LIB, of the PSNI. Before the inquiry commenced, Ms McQuillan initiated judicial review proceedings seeking a declaration that the LIB was not sufficiently independent to conduct the investigation, and that this amounted to a breach of Article 2 of the Convention, which called for an independent and effective investigation of such events. As I have said, the Hooded Men were subjected to unacceptable ill treatment in August 1971. Nobody has ever been prosecuted for authorising or carrying out such treatment. In the 1970s, the Hooded Men brought civil claims against UK ministers, which were settled by the payment of compensation. The Republic of Ireland brought an interstate application to the European Commission on Human Rights and subsequently to the European Court of Human Rights against the United Kingdom concerning the ill treatment of the Hooded Men. The Strasbourg Court, in its judgment in 1978, held that the techniques constituting the ill treatment had been authorised at a high level and amounted to a state practice. The court determined that the treatment of the Hooded Men constituted inhuman and degrading treatment in breach of Article 3 of the Convention, but did not amount to torture. In 2014, the Irish national broadcaster, Radio Televisión, broadcast a documentary about the Hooded Men. It referred to documents which had been deposited in the UK National Archives in 2003 and which had not been before the Commission or the Strasbourg Court, and a memorandum by the Home Secretary, Mr. Rees, to the Prime Minister, dated March 1977, which referred to the use of the techniques on the Hooded Men as torture and to the approval by UK ministers of such techniques. Following the RTE documentary, The PSNI considered whether there was sufficient evidence to warrant a further investigation into the allegation that the UK government had authorised the use of torture in Northern Ireland. In a decision on 17th October 2014, the Assistant Chief Constable of the PSNI concluded that there was not sufficient evidence. Mr McGuigan and Ms McKenna challenged that decision in their judicial review application. Separately, the Irish government applied to the Strasbourg court for a revision of the judgment which it made in 1978, requesting that the finding of inhuman and degrading treatment be replaced by a finding of torture. The Strasbourg court, in a judgment issued on 20th March 2018, dismissed that request. The judgment of a 7-justice panel of this court has been prepared by Lord Lloyd-Jones, Lord Sales, Lord Leggett and myself, and is agreed by Lord Kitchen, Lord Hamblin and Lord Burrows. In the judgment, we seek to give guidance on the investigative obligations under Articles 2 and 3 of the Convention as applied to domestic law by the Human Rights Act 1998. The coming to light of new evidence can cause an obligation to investigate an event of the past to be revived in accordance with the judgment of the Strasbourg Court in Bracknell and the United Kingdom. This court holds that, other things being equal, the information in the military logs was of a nature that would revive the investigative obligation, but that the information relating to the authorization of the techniques used on the hooded men, which was disclosed in 2014, did not add significantly or alter the substance of the state of knowledge that existed in 1978. Accordingly, the PSNI was not under a duty under Article 3 of the Convention to investigate the authorization of the ill treatment of the hooded men. On the question of the time gap of about 28 years between the relevant events and the coming into force of the Human Rights Act in October 2000, the court applies the tests laid down by the Grand Chamber of the Strasbourg Court in the case of Janovich. The genuine connection test comprises 2 elements, both of which must be satisfied. First, the lapse of time between the events and the critical date, which this court holds to be the coming into operation of the Human Rights Act, must be reasonably short. And secondly, a major part of the investigation must have been carried out or ought to have been carried out after that critical date. The Bracknell test, which I have mentioned, is itself subject to the genuine connection test. Thus, although the information in the military logs was of a nature that met the Bracknell criteria as to its content, the application of Ms McQuillan did not meet the first element of the genuine connection test, with the result that the PSNI was not under an obligation under Article 2 of the Convention to investigate Ms Smyth's death. Notwithstanding those conclusions, the court gives further guidance on the application of the investigative obligation under those articles of the Convention and the question of the independence of the PSNI, which is a matter of contention in Northern Ireland. The investigative obligation on a state under Article 2 or Article 3 of the Convention is fulfilled only if the investigation is effective. If Article 2 of the Convention had applied to the investigation of the death of Ms Smyth, the Court of Appeal would have been entitled to conclude that the proposed investigation would not have been effective. This is not because the legacy investigation branch of the PSNI has an institutional or hierarchical connection with those that might be implicated in the event under investigation. As the Court of Appeal held, it has not. Nor is it because it was established that the LIB was not capable of conducting an investigation with practical independence. In an important judgment in the case of Tunk against Turkey, which was not put before Mr Justice Maguire or the Court of Appeal in Northern Ireland, the Grand Chamber of the Strasbourg Court has explained 2 matters. First, It will rarely be possible to determine that an investigation will not be effective because of a lack of practical independence until it is completed. And secondly, the elements which establish the effectiveness of such an investigation are interrelated and include the involvement of the deceased person's family. Having regard to that second point, this court concludes that the Court of Appeal would have been entitled to conclude that the investigation by the LIB into Ms Smyth's death would not have been effective because, in the particular circumstances of the case, that is, against the background of past failures and inadequacies in the investigation of her death, the Chief Constable had failed to explain to her family, and more widely to the general public, and when faced with judicial review, how he proposed to secure the practical independence of the investigation. By contrast, the court is satisfied that the Court of Appeal erred in concluding that an inquiry by the LIB into the ill treatment of Mr McGuigan and Mr McKenna would lack practical independence. Turning to the other challenges in domestic law, the court concludes that the PSNI was not under an obligation at common law or under the Police Northern Ireland Act 2000, which was equivalent to the obligation under Article 2 or Article 3 of the Convention. The court also rejects the contention that the Chief Constable had created a legitimate expectation in relation to the investigation of the treatment of the hooded men. It is, however, satisfied that the PSNI's decision, taken on 17 October 2014, not to investigate further the allegation in the Rees Memorandum, was based on a seriously flawed report, and that it was therefore irrational and falls to be quashed. The court therefore allows the appeals of the Chief Constable, the Secretary of State for Northern Ireland, and the Northern Ireland Department of Justice, and recalls the orders of the courts below. The court upholds the decision of Mr Justice Maguire and the majority of the Court of Appeal to quash the decision taken on 17 October 2014, but otherwise dismisses the applications for judicial review.